Okay, let's begin now. Good afternoon to everyone here in Hong Kong and buenos dias to those joining in Spain. Welcome to this joint webinar of the Madrid Bar Association and the Law Society of Hong Kong. Our topic today is doing business in Hong Kong and Spain. Before we start, we have a few housekeeping points for you. In this webinar, you are automatically muted in listening mode only. Simultaneous interpretation in English and Spanish is available for this webinar, so please select the audio channel to hear your language of choice. The chat room allows you to send messages to the host, panelists, and other attendees. And so, if you have any questions for the speakers, please feel free to type your question in the Q&A box during or after our presentations. We will then take your questions at the end. So without further ado, I will hand over to Maria to kickstart our welcoming remarks. Maria, thank you.
Welcome, everybody, and thank you all for joining this webinar, doing business between Hong Kong and Spain. Co-organized between the Law Society of Hong Kong and the Madrid Bar Association. I am Maria Segimon. I am a board member of the Madrid Bar Association, Head of International Affairs, and I am honored to welcome you to what I believe will be an extraordinary opportunity to get to know a little more about our two countries and about our two jurisdictions and facilitate contacts among law practitioners in both jurisdictions. This webinar will be organized in two panels after the President of the Law Society of Hong Kong and the President of the Madrid Bar Association have had the floor. One will be the Spanish perspective and will be in which Mr. Borja Díaz-Guerra, Corporate and M&A Partner in Écija, lawyer and solicitor and General Secretary of the National Representative of the European Lawyer Association, will participate, and also Mr. Juan Martín Perroto, partner of the Madrid office of Uría and Menendez and head of the Asia practice of the firm. Therefore, and with no more delay, I have the pleasure of introducing you to the President of the Law Society of the Hong Kong Bar Association, Mr. Chan. Mr. Chan, please.
Thank you, Maria. Can you all hear me?
Yeah.
Yes.
Thank you. Mr. Jose Maria Alonso Puig, Dean of Madrid Bar Association, distinguished speakers, members of the Law Society of Hong Kong and Madrid Bar Association, good morning or good afternoon, depending where you're from. It gives me great pleasure to welcome you all to this webinar jointly organized by the Law Society of Hong Kong and the Madrid Bar Association. Facilitating new business opportunities for members is one of the Law Society of Hong Kong's important roles. Through the years, we have established extensive connections with lawyers, associations, and legal associations in different overseas jurisdictions, laying a good foundation for collaboration on activities that are beneficial to the respective members and legal professions. We have been working closely with the Madrid Bar Association on several occasions to advance the legal profession in both jurisdictions. To formalize our commitments to collaborate and support each other, a memorandum of understanding was signed in April 2016. There is no doubt that we will continue our effort in exploring ways to foster collaboration and to strengthen our members' exchanges. The uninvited visit of COVID-19 has brought international travel to almost a complete halt and stopped all physical business activities, meetings, and seminars. Fortunately, technology has allowed us to remain connected unhindered by geographic separation by co-organizing this webinar. It is very encouraging to know that over 140 members are joining us today to learn more about doing business in Hong Kong and Spain. Before inviting our distinguished speakers to talk about how to set up business in Hong Kong and Spain, and highlights the respective market advantages, allow me to briefly introduce the bilateral trading relationship between Hong Kong and Spain, Hong Kong's business environment and legal system. I was just checking on the website that there are still direct flights between Madrid and Hong Kong, so you can still do the traveling. So Spain is a close trading and investment partner of Hong Kong. On the trade front, Spain was Hong Kong's 6th largest trading partner, 5th largest export market, and the 7th largest import market in the EU in 2020. As for bilateral investment, Hong Kong was the 3rd largest destination in Asia for Spanish investors in 2019. For the same year, Hong Kong investors also made substantial investment in Spain, with the city ranked the 4th largest Asian investor in the country. As a leading international financial center, Hong Kong is one of the world's best places to do business. Hong Kong's free trade policy and easy customs procedures make it easier for businesses and companies to operate. Businesses and individuals in Hong Kong can also enjoy one of the most tax-friendly systems in the world, famous for its low-tax regime. For instance, in the Economic Freedom of the World 2021 annual report of the Fraser Institute, Hong Kong was the world's freest economy since 1996. Among the 5 areas of assessment, Hong Kong continued to rank top in freedom to trade internationally and regulation. Hong Kong has a well-established legal system firmly based on the rule of law and an independent judiciary. Under the principle of one country, two systems, on the one hand, Hong Kong is part of China. On the other hand, Hong Kong is a special administrative region with our own economic system and way of life remain unchanged for 50 years after the handover, i.e. 2047. Hong Kong's legal system is based on the common law as entrenched in the Basic Law, which is our constitutional document. Being the only common law jurisdiction within China, the tried and trusted legal system of Hong Kong is always a cornerstone of our success. Hong Kong's open door policy has successfully attracted legal talent from around the world, enriching the diversity of Hong Kong's legal services market. As of the end of February, there were around 11,000 Hong Kong practicing solicitors and 941 local law firms, as well as around 1,500 foreign lawyers from 34 different overseas jurisdictions and 83 foreign law firms in Hong Kong. There was, in fact, one Spanish law firm registered as a foreign law firm in Hong Kong in the past, a few years ago. English and Chinese are both official languages and are commonly used in business. What's more, Hong Kong is a neutral dispute resolution venue with world-class arbitration and mediation institutions such as the Hong Kong International Arbitration Center, International Commercial Chamber of Commerce, and CITEC, the Chinese Arbitration Center, and with professionals that are capable of providing efficient and reliable dispute resolution services. Robust legal infrastructure and financial system, a business-friendly environment, abundance of multi-jurisdictional legal talents, as well as close connection and cooperation with mainland China, provide the necessary high-end professional service support to foreign investors. These unique characteristics have enabled Hong Kong to build up its global reputation as a leading financial and business hub. So to conclude, I hope you will find our joint webinar to be an informative and rewarding experience and would be interested in setting up your business in Hong Kong or to expand your business into Asia and China via Hong Kong. Thank you very much for your attention.
Thank you very much, Mr. Chan. It's very interesting and very encouraging for both jurisdictions. Now I'm really honored to give the floor to my president, Mr. Jose Maria Alonso, President of the Madrid Bar Association. Jose Maria, please.
Thank you, Maria. Good morning, everyone from Spain. Thank you, Mr. Chan, for your words. It's a real pleasure for the Madrid Bar Association to organize this virtual event together with the Law Society of Hong Kong. And for me, as president of the Madrid Bar Association, which is the largest bar association in Europe with more than 76,000 members, it's an honor to inaugurate this event because it is an opportunity to continue strengthening the relationships between these two institutions, the Law Society of Hong Kong and the Madrid Bar Association, which are without a doubt two reference of the law professional in the respective regions. Since the signing of the Memorandum of Understanding between the Law Society and the Law Society of Hong Kong and the Madrid Bar Association, to which Mr. Chance has referred to, these two institutions have maintained a permanent and fluid communication channel, allowing both of us to have a more efficient and permanent collaboration. Moreover, I would like to congratulate the Law Society of Hong Kong for consistently organizing legal events that have become landmarks forums for the bar associations and legal professionals all over the world. Events such as the President's Roundtable and the opening of the legal year are and will be in the long term mandatory dates in the Madrid Bar's calendar. Events like this, one must only be the starting point for colleagues to discuss practical matters, to seek solutions to common problems in relation to cross-border practices, exchange legal and business knowledge, in addition to being point of liaison with other jurisdictions where legal practitioners may wish to practice. Indeed, due to this increasing competition in the legal sector, the usefulness of these encounters between colleagues from different jurisdictions grows constantly. This fierce competition forces us to constantly improve ourselves, to create networks quicker and find synergies that can take our daily practice to a different level. Besides, today I would like to highlight that the two jurisdictions, Hong Kong and Spain, the city of Madrid in particular, have two common important characteristics. First, companies constantly come from all continents to Hong Kong and Spain, and especially to Madrid, with the conviction that they will find world-class legal services, highly qualified lawyers and expert judges in specialized courts, which are a guarantee to promote commercial relationships and the creation of businesses. Both Hong Kong and Madrid are governed by the rule of law. Second, both jurisdictions are ideal gateway to other important markets. Hong Kong is a long-standing gateway to the rest of the Asian market, which, as you will all know, is experiencing an incessant growth in the last few years. In the case of Spain, our country has for many years served as the natural and perfect gateway for international lawyers and companies to enter the Latin American market. Countries with which we share legal tradition, language, and most importantly, a natural and undeniable connection. Spain has a very strong strategic location and deep trade partnerships with access to the markets of the EMEA, Europe, Middle East, and North Africa. Additionally, Spain, as you well know, is an important member of the European Union, which also grants direct and privileged access to the world's largest common market, one with 500 million people. In the same line with the prior, it is important to note that the investments between the two jurisdictions, as Mr. Chan has highlighted, Hong Kong and Spain, have been increasing substantially in the last decade, tendency that it is expected to continue in the years to come. Also, as Hong Kong, with the arbitration court in Hong Kong, Madrid has created the Madrid Jurisdictional International Arbitration Center, just to be a point of connection of all the speaking countries in the world. Today, more than 600 people speak Spanish across the world, which is something extremely important. And this center tends to be, I mean, the reference of arbitration in international cases. Today, we have the opportunity to learn from distinguished speakers with a very solid background in corporate and international law, how in practice businesses should be done in Hong Kong and Spain. So thanks again, thanks to those that have made possible to organizing this important event. You can be sure, Mr. Chan, that we will be, I mean, totally committed to strengthening our relationship between the two I mean, legal bodies. We think Hong Kong is very, very important for Spain, and we will, as I say, try to be permanently in contact and try to do things in common. I will probably ask you to join when we do something with Latin America, because I think it is very important, this connection between Europe, Asia, and Latin America. Thank you very much.
Thank you so much, President. Thank you both. Now I have the pleasure of introducing you to the moderator of these two panels. Sorry, I didn't say that the second panel will be participated by Mr. Neville Cheng, member of the International Legal Affairs Committee of the Law Society of Hong Kong, and Ms. Heidi Chui, member of the International Legal Affairs Committee of the Law Society of Hong Kong. And now I have the pleasure of introducing you to Alison Tsoi. She will be the moderator of both panels. She has been serving as a member of the International Legal Affairs Committee and a member of the In-House Lawyers Committee of the Law Society of Hong Kong, and is currently the legal counsel at Kerry Holdings Limited, the investment holding company of Kwok Group, which is a multinational conglomerate. She's primarily responsible for advising on the legal and regulatory affairs of the investment, financing, and corporate work of Kerry Holdings Limited and its affiliates entities. Thank you very much, Alison, for taking the floor now and moderating both panels for all participants. Thanks very much.
Thank you, Maria, for introducing me, and thanks very much to CM and Jose Maria for the welcome remarks. We'll now first have a presentation on behalf of the Madrid Bar Association. I'm delighted to introduce our speakers, Borja and Juan Martin. Borja is a partner of the Corporate and M&A practice at Athija and the General Secretary and National Representative of the European Lawyers Association. In addition to being a lawyer in Spain, Borja is also admitted as Solicitor of England and Wales. He has more than 15 years of experience in commercial and corporate advisory matters, with special focus on corporate transactions, investment and divestment processes in different jurisdictions, and corporate restructurings. Juan Martin is a corporate partner at Uria Menendez. Juan Martin spent his career living and practicing law in Latin America, Europe, and Asia, where he lived in Beijing for 5 years. He is part of the Asia Group and of the Latin America Group of his firm Uria. He is a member of the UN Expert Group of Good Practices in Infrastructure Development and an arbitrator for CTAC and several other arbitration panels in Asia. Juan Martin's focus of expertise is M&A and infrastructure work. So may I now hand over to Borja and Juan Martin, please? Thank you.
Okay, do you hear me?
Yes, we can hear you, Borja. Thank you.
Okay. Thank you, Alison, for your warm welcome. Also to Maria Sejiman, President Mr. Chan, President Jose Maria Alonso, distinguished attendees, panelists, moderator, and also interpreters. Good morning to everyone in Spain, and also good afternoon to everyone in Hong Kong. Let me share with you a brief presentation. Let me upload it. Here we go. So I would like to provide you a brief overview of how to set up a business in Spain, how are the typical structures we use or the foreigners or foreign investors use in Spain. I will also provide you a brief walk through a description of the Spanish limited companies, the different types, the two main types of limited liability companies we have. We will end up with a brief overview also about the main aspects of corporate governance in the Spanish limited companies. So these are perhaps the most common structures that are used by foreign investors or for investments in Spain. The first ones would be, which perhaps is the most common one, would be to use a limited company. Here in Spain, we have two main types of limited companies, which are the public limited companies, which are called Sociedades Anónimas or the so-called SAs. And also we have limited liability companies, which are the Sociedades de Responsabilidad Limitadas or the so-called SL. Obviously, these types of companies enjoy the limited liability regime. They have legal personality. They can obtain a tax identification number to get registered at the Social Security, hire employees, and in general terms to carry out business here in Spain. I will further develop the two main types of limited companies in the next point. You can also have, perhaps the order is not correct, but you can also have another structure which is called branch, which is in Spanish is sucursal. This is also a typical structure for foreign investors or foreign companies investing in Spain. Perhaps the main difference with the limited liability companies or limited companies is that it doesn't have legal personality, but it is kind of an extension of the parent company, of the foreign company establishing the branch in Spain. Branches are, for the establishment of branches here in Spain, you need to do it through the execution of the corresponding public deed, and also they need to get registered at the commercial registry. a branch can obtain a tax identification number and also to get registered at the Social Security and to hire employees. So it is quite common to have branches for foreign groups. And then there would be another possibility, which perhaps is the latest structure you may have in Spain, which could be the representative offices. These structures are very light, particularly or normally addressed for ancillary or instrumental activities. It is quite straightforward. The process for establishing a representative office, you just need to incorporate or to establish the rep office through the execution of a public deed, and it wouldn't be subject to registration at the commercial registry. Despite of not being subject to registration, it is able to get a tax identification number, to get also registered at the Social Security, and to hire employees. And then perhaps it is also common to have commercial joint ventures or equity joint ventures. Commercial joint ventures at the end of the day is two or more companies normally participated by foreign companies, which doesn't have a formal structure like the other ones, like public limited companies or limited liability companies, but the structure is made through a contractual relationship. And equity joint ventures. Equity joint ventures at the end of the day is it's normally one limited liability company or public limited company, which is participated by two or more investors or shareholders, and obviously or normally with a specific business purpose to carry out business here in Spain. So we move to the second point. As I mentioned before, the structure normally used, or which is quite common to be used by foreign investors, could be to have limited companies. The main two types of limited companies in Spain are the public limited companies, SAs, and the SLs, the limited liability companies. Both types of businesses or companies are regulated in the same law, in the Spanish Companies Act. Both types of companies share the same some common provisions, but there are some differences between them. So perhaps these ones are the most general ones. There are other ones, but to give you an overview, the minimum share capital of an SA would be 60,000 euros, and for an SL would be 3,000 euros. The shares in an SA are called or are considered as securities or book entries. In SLs are not considered securities. In terms of the transfer of shares, the SAs are more open companies, so the restrictions on the transfer of shares are less restrictive. And in comparison to that, limited liability companies are closer. The restrictions on the transfer of shares are more restricted by default. Obviously, these two things, or the transfer of share regimes, and in the same way that happened with other elements of the two companies, can be slightly modified in the corporate bylaws and also through the proper or the corresponding shareholders agreement. The independent report, that's another point, which is there is a difference here between both companies. For contributions of non-monetary contributions in share capital for the SAs, you could need an independent report. And for SLs, it is not non-mandatory. Sometimes recommended, but non-mandatory. And well, obviously the common element for both of them is that the main common element for both of them is that there is a limitation the liability to the capital contributed by the shareholders. So I wanted also to provide you a tentative incorporation timeline. Obviously, this applies on a case-by-case basis, depending on the jurisdiction involved of the investing company. But perhaps this could be the average. 3 weeks. I'm not sure if you can read this, but 3 weeks until the company has legal personality, and another 3 weeks for certain post formalities that will need to be carried out here in Spain. Just to provide you a brief summary, I believe Hong Kong is part of the Hague Convention, which is very useful for when it comes to foreign investors, because with the apostille you can prove authenticity of the documents granted abroad, so to have validity here in Spain, as in the other countries forming part of this convention. So we could need here to have a power of attorney for the incorporation of the company, and also to obtain the tax identification number of the foreign company. This is required, that the foreign company obtain a tax identification and a Spanish tax identification number for the incorporation, and also for the NIE number. It is called NIE number here in Spain, is the foreign identification number of the future directors of the company, as long as such directors are non-resident here in Spain. With also, there will be a need to reserve the corporate name of the company, which is very straightforward. To open the bank account, for the opening of the bank account, it would be needed to contribute the share capital of the company, and with that, and also with the bylaws, which will regulate the relationship between the shareholders, the incorporation public deed at the Spanish notary could be executed. From this point, from the execution of the public incorporation public deed, such company would have legal personality. Okay. However, there are some post formalities also apply. For example, that the new company would need to obtain a tax identification number, and also to be filed and registered at the commercial registry. So the third point could be perhaps this point. It is makes more sense when foreign investors are entering into the market in a company having a minority or majority stake. If the foreign investors are entering into the Spanish market with a sole shareholder company, meaning 100% of the company, having 100% of the company, this could be of second priority. However, when it comes to investments, joint investments with other shareholders, this could be important. The main two bodies in the limited companies are the Shareholders Meeting and the governing body. The Shareholders Meeting will mainly deal with the structural things of the company, with the modification of the bylaws, the approval of the accounts, the appointment of auditors, the appointment also of the directors, and the decision of the type of governing body, and so on. And the governing body, which would be in a way below the Shareholders Meeting, would be in charge of the day-to-day business affairs of the company. When it comes to shareholders' rights, the main ones, there are many, but the main ones could be that the shareholders could be the right to the allocation of benefits or profits under a liquidation quota in case of liquidation of the company, preemptive rights for new shares in increase of capital. This is not absolute. There are some exceptions sometimes, but in general terms, there are preemptive rights for all the shareholders. The right to vote in the general shareholders meeting, the right to challenge corporate resolutions which perhaps were not properly adopted, and the right of information rights. And about the governing body, different types of governing body. As I mentioned before, the governing body will be in charge of, will deal with the day-to-day business affairs of the company, with the management of the company. You can, okay. You can have different types of governing bodies. You can have a sole director. You can have joint and several directors, which means that each of such directors can represent the company with their own signature. You can have joint directors, meaning that all these joint directors have jointly, for the representation of the company, all these directors need to act jointly. And you can have also a board of directors. There's another difference between SLs and SAs when it comes to board of directors. Board of directors needs to have at least 3 members, and for SLs up to 12 members. In SAs, there's no limit on this. So just for your visibility in the Spanish market, as I mentioned before, the main structure normally is to have limited companies. Perhaps, despite there are some other structures, like I mentioned before, branches and also rep offices. The decision on that, because of all the presentation, it's addressed from a corporate perspective. But please take into account that the decision for that going to one structure or the other has to be properly assessed also from a tax perspective, just to assess any kind of tax impact that this structure may have on the parent company or on the future business to be developed. And perhaps between all these structures I mentioned, perhaps the most common one would be the limited liability companies, the SL. I believe more than 90% of the companies in the market in the Spanish market are SLs, and the reason probably it's because of the flexibility and also because it is cheaper in a way to incorporate and easier to manage. So I'm not sure if obviously there's some space now at the end of the meeting for a Q&A. So in case you would like to get deeply in one of these points, we can talk about them later on the Q&A. I hope you enjoyed the presentation and overview. Thanks to all, particularly to the interpreter. Hopefully she has not suffered too much my speech. So I give the floor to Alison again.
Thank you very much, Borja. So may I now hand over to Juan Martin, who will continue the presentation and tell us more about the Spanish environment and how to do business in Spain. Juan Martin.
Thanks, Alison. Thanks for inviting me, and Jose Maria and Mr. Chan for organizing this. I'm not sure if my screen is being shared.
Yes, it is. It is on the screen.
Okay. Thank you. So, I mean, just after what Borja described, just to give you a 10,000 feet overview of investing in Spain, mostly from a regulatory perspective, and in 3 areas, which would be a direct investment, a joint venture, or a greenfield project. Just a few words. I mean, as a foreign practitioner, I have practiced law in Latin America, Alison, and China, and in Europe for several years where I have lived. But if you give any credit to my word, I can tell that as a foreign practitioner, I found Spain to be in the extreme of openness, and this is what statistics says, and ranks Spain as the 10th most open country to FDI. So our Hong Kong colleagues will identify with that because Hong Kong is mostly the same. And that has reflected in inflows. Spain is a net inflow destination for investment and ranks 11th in the world. But what is more interesting is that, and this has been the case with Chinese investments, it's also one of the main leading destinations for greenfield projects, number 5 in the world, in spite of a few things or setbacks that I will describe. In terms of investing directly in Spain, not greenfield projects, but acquiring a company, 2 things are important if you are and may explain the attractiveness of Spain as a destination for foreign direct investments. The first one is if you acquire a company through an SPA, a share purchase agreement, you expect that the contract is complied with, and in that regard, Spain, in terms of enforcement of contracts, presents a fairly welcoming system. And basically, this is an word overview to which our firm contributes. This a case study, and with the same type of claim, same amount, and same characteristics and features to enforce a claim in Spain, you will spend a certain amount of days and money. In terms of how quickly our courts react, Spain ranks below Hong Kong. You will get an enforcement of that award of that court decision in roughly 1.5 years. In Hong Kong is less, but still, the good news is that litigating in Spain is much more cheaper than in Hong Kong. Overall, to other peers in Europe, Southern European countries, as you will see in the left column, Spain ranks fairly high. If instead you partner with another person in a joint venture, as Borja explained, Spain also offers a great deal of protection in terms of minority rights and court protections for minorities. Again, well ahead of other European peers, and this is an area that is subject to common rules under European law, under the second directive of corporate governance, etc. But still, Spain on this, you will not find any unpleasant surprises. Where you may find unpleasant surprises is in greenfield projects where permits are important, and here, unfortunately, Spain has a lot of work to do. Spain is a very decentralized country, unlike Hong Kong. We have 3 levels of government, municipalities, regional government, state government, and all claim a permit. A client of ours to build a port has had to go through 180 permits, and that is something that is not acceptable, and we need to change. In spite of that, as I said before, Spain has not. I mean, this feature has not shied away international investors, and Spain still is one of the leading destinations from greenfield projects. And that again has to do both direct investments and greenfield projects with three basic features that were mentioned before. One is, in general, you don't need authorizations to invest. There are no capital restrictions, as you will find in China or in some other Latin American countries. And tax-wise is Spain has, as Jose Maria mentioned, a wide network of treaties, including one with Hong Kong, under which dividends, for example, are generally not subject to any withholding, or dividends and capital gains. So on that regard, that is certainly a feature that attracts foreign investment. There is, however, and this is recent, and what I'm going to say now is enshrined in a regulation. So this is the same for all European jurisdictions. There is a FDI clearance. You need, depending on the target company you are acquiring or investing in, or the type of investor you are, you may need an authorization when you are a non-European investor or a company which ultimate beneficiary owner is a non-European investor. When you acquire more than 10% in a company, to the extent that company is engaged in certain sectors, or you are a certain type of investor, you will need to get an approval from the national authority, in this case, the Spanish Council of Ministers. The type of industries or sectors where you will need an authorization are the typical ones: critical infrastructure and technologies, critical inputs as energy or raw materials, media. And one that is very fashionable nowadays, which is those sectors with access to sensitive information, including personal data. This is the new economy, and wherever data is managed as a massive scale, you will need to get an authorization to buy that company. Irrespective of the sectors, those investors that have been punished for illegal activities or have invested in critical sectors in other countries, we need also an authorization, again, irrespective of the sector. And what is relevant perhaps to you, particularly for mainland Chinese investors, is that authorizations will always be needed when the investor is controlled by a government, an SOE or a sovereign wealth fund. Other than that, there are obviously a number of authorizations that are required in certain sectors, irrespective if you are a foreign or local investors. But these again are the typical ones: power and gas. If you want to buy a company that is engaged in a transport, storage, generation of power, or distribution or transmission of power or gas, you will need an authorization when, and this is a soft test, whenever it might affect the security or supply of gas or power, and this is a soft test. It's not written on the wall. You have to analyze that with your lawyers. Obviously, a small power generation company will not raise these concerns. Others might raise. Financial and insurance entities, as in Hong Kong, you will need to provide prior notice if you acquire 5% stake in a bank, or an approval if you go over 10. For infrastructure concessions as well, if you acquire control. And then there are limitations for flag carriers that cannot keep the slots. If you acquire, if a foreigner acquires a national carrier, and the other limitation in the power sector results from unbundling. Same person cannot control the production, generation, supply, and transport of power, so you will have to choose, or otherwise sterilize your shares and don't have any vote. What is interesting, I also think, for Hong Kong practitioners is a project of at the European level of a regulation that for M&A acquisition, for acquisition of European companies, or to participate in public tenders, if the target company has a turnover in the EU in excess of 500 million euros, and the purchaser has received subsidies, public aid, and this includes public financing, public policy financing, for example, one granted by the Chinese Development Bank, in excess of 50 million in the last 3 years, then you will have to go through a special screening similar to antitrust screening. And this is intended to protect, to avoid that subsidies interfere with, has a distorted effect in the market. So this was raised by Chinese companies and controlled by the government that received the very, very cheap financing, and as a reaction to that, the authorities are in the process of enacting this regulation. This does not mean that they will not be approved, but that these investments will be scrutinized. Lastly, and I finish with this, there are also, if you acquire a company in Europe and that company is listed, you have to keep an eye in regulations that are similar to the ones in Hong Kong. You will have to disclose whenever you acquire more than 3 or 5%, or 1% if the investor is in a tax haven, and any multiple of 5%. So whenever you acquire that level of stake, you will have to go public and disclose it to the market, and this might be uncomfortable in certain cases. If you go over 30%, you will have to launch a mandatory tender offer. But again, this is something that is probably a feature that is common with Hong Kong, and that not that many investments that result in this. So with this, I wrap up, and I leave the floor again to Alison. Thank you.
So next up, we will have a presentation on behalf of the Law Society of Hong Kong. As for our speakers, I'm delighted to introduce Neville and Heidi. They both serve in the International Legal Affairs Committee of the Law Society of Hong Kong together with myself. Neville is a partner of Fong's, a Hong Kong law firm providing cross-border legal services with joint venture law offices, Zhongyin Law Firm of Mainland China and Ratto Ling Lee and Cortis of Macau. The firm is also in association with Spencer West LLP of the UK. Neville is the Vice Chairman of the Greater China Legal Affairs Committee and a member of the International Legal Affairs Committee of the Law Society of Hong Kong. He is also a professional accountant and dedicates to provide corporate and commercial legal services to clients. Heidi is a partner of the Hong Kong law firm Stevenson Wong & Co. in association with the PRC law firm Albright Law Offices. She heads the Banking and Finance Department and the Dispute Resolution Department of her firm. Heidi is a member of the International Legal Affairs Committee, Greater China Legal Affairs Committee, Arbitration Committee, and Innotech Committee of the Law Society of Hong Kong. She advises clients on cross-border financing transactions and also international trade and investment disputes. So may I now hand over to Neville and Heidi. Thank you.
Good afternoon to our Law Society members, and good morning to those in Spain. Okay, let me start now. So Hong Kong maintains a free trade economic policy. With its proximity to the market of mainland China, it has become one of the most attractive places for investment, and is also one of the most favorable destinations for multinational companies to set up their Asia Pacific headquarters. For businessmen, their main concern may be business opportunities, but for us, lawyers will be concerned more about the vehicle or entities that we may assist our client to set up for their business ventures. The most common type of business entity would be limited company, then partnership, and more directly as the sole proprietor. Hong Kong company, the most common type is company limited by shares. One may also incorporate an unlimited liability company, but it is quite unusual. If you want to set up a new company, you should have registered one at the Hong Kong Companies Registry, but you may also use an existing foreign company to set up a branch in Hong Kong to do the business here. If you do not want or are not allowed to use a corporation, you may carry on a business in partnership or doing it alone as a sole proprietor. The procedure for setting up a Hong Kong company is rather simple and may be done through the internet. There is no minimum capital requirement. The share capital of a private company may be as little as $1 Hong Kong or €1. It may only have one shareholder. The shareholder may be a natural person or an other corporation without any nationality or residence requirement. He or she may be a Chinese, a Spanish, or an other company incorporated elsewhere in the world. If it is registered as a private company, the number of shareholders shall be limited to 50. If there is a plan to have it listed at any stock exchange, then it should be registered as a non-private company and be subject to more rules and regulations. So today, I will mainly introduce the information about private company in Hong Kong. While shareholders are the investors, directors are the person in actual control of the operation and management of the company. The minimum number of directors for a company is only one, who must be a natural person. If a company has more than one director, the other directors may be companies incorporated in Hong Kong or elsewhere. For natural persons, the director must be aged 18 or above and not a bankrupt or under any disqualification order. Like shareholders, there's no residence or nationality requirements for a director. A director may operate and manage the business remotely from any place outside Hong Kong. There's no shareholding requirements for a director unless the bylaw or what we call the Articles of Association of the company so require. A Hong Kong limited company must have at least one company secretary, who should be a natural person ordinarily residing in Hong Kong or be another company having a place of business in Hong Kong. Many Hong Kong legal and accounting professionals would offer the services by providing a nominee company as the company secretary for fulfilling the legal requirement. Register office is the official address for accepting service of legal documents and keeping of statutory records, including books of accounts of the company and various registers of records, such as the register of directors and shareholders. Every Hong Kong company must have a registered office in Hong Kong, and it may not have to be its place of business. Again, many professional legal and accounting practitioners would provide registered office service to let you register your company at their office. The name of the company must then be displayed at the entrance, but of course, they will not allow you to operate your business at their office. But the law also required a significant controller register so as to identify the person in actual control of the company. The company shall identify a natural person in ultimate control directly or indirectly with not less than 25% of the shares or the voting rights in the company. If the one in ultimate control is a company listed on any recognized stock exchange, that company shall be the significant controller. Now, every Hong Kong company shall hold a general meeting of shareholders every year for approving the annual audited account of the company and for appointing the auditor for the next year. If the company has only one shareholder, such general meeting may be waived, or it may also be held in paper form by signing for approval by all shareholders in the place of an actual meeting. For private company, the financial records and accounts of the company are internal records. There is no filing or disclosure requirement, and the external third parties may not be able to access through any public channel. A company not established in Hong Kong may also run a business by setting up a branch office in Hong Kong. When it has a place of business in Hong Kong, it shall register at the Hong Kong Companies Registry as a foreign company. It will be assigned a company number with the prefix of letter F. It must also appoint a natural person residing in Hong Kong as the authorized representative of the company with authority to accept service of legal documents. For partnership, we adopt the common law principle of partnership. The laws of Hong Kong requires some business must not be conducted by a limited company, such as lawyers. So we must practice in the form of partnership or doing it alone as a sole practitioner. Limited liability partnership may also be set up in Hong Kong with at least one general partner bearing unlimited liability, where the other partner's liability may be limited. For lawyers' practice, we may also have limited liability partnership. The limit on liability is not on monetary term, but on the area of practice that an individual partner is responsible for in the firm. If you want to run a personal business in Hong Kong, you may also run it as a sole proprietor. So another concern is about the visa. Although there is no residence requirement for being a shareholder or director of a Hong Kong company, if eventually a natural person has to come to Hong Kong to conduct business, a visa or permit to enter and stay in Hong Kong is still necessary. A person holding a Spanish passport may come and stay in Hong Kong as a tourist for a period of 90 days without a visa. Limited business activities without visa are allowed, such as for concluding contract, submitting tenders, participating in exhibitions, but must be without selling activities, and for attending short-term seminars and business meetings. One of a businessman's main concern is tax. The tax system in Hong Kong is simple and the tax rate is quite low. There are only three kinds of tax, namely profit tax, salary tax, and property tax, and an additional one, stamp duty. We adopt a territorial system of charging tax. We have no VAT, no withholding tax, and no tax on dividend paid by a limited company to its shareholders. The profit of a capital nature is tax-free. For example, if you buy a house in Hong Kong and let it out for rental income, it is therefore an investment asset. After several years, when the property market is good, the price inflated, and you sell it out for a good profit, such profit is capital in nature and would be tax-free. However, if you are a real estate developer or a trader, the landed properties in your hands would be your trading stock, and the profit will be considered as trading income instead of capital revenue and be subject to tax. And for dividend, the principle is that the same income will not be taxed twice. Therefore, dividends distributed by a limited company to its shareholders would not be taxed while coming into the hands of the shareholders, because it is the after-tax profit of the company, and the company has already paid the tax on it. By applying the territorial source principle, a company or person shall only be liable to pay tax if it carry on a trade, profession, or business in Hong Kong, and it has accessible profit arising in or derived from Hong Kong. So a Hong Kong company, even if it has made a very substantial or large amount of profit, it still may not have to pay tax if in Hong Kong it either does not conduct any business activities here, or the profit is not earned from any business activities in Hong Kong. But the tax rate is relatively very low. There's no business tax. Profit tax is only charged on net profit of the business annually. For company, the current rate of tax is 16.5%, and for individual is 15%, and maybe at a progressive rate from 2 to 17% if finally a lower amount of tax is so charged. And here we now have a concession for the first 2 million Hong Kong dollar of profit. The tax rate will be half. That is 8.25 for corporation and 7.5 for an individual. Although the territorial source principle appears very attractive to businessmen, there's a lot of criteria and rulings laid down by court cases that a taxpayer must fulfill before one may be entitled to the benefit. Firstly, it is the operation tax. Considerations include where the business is operated, where is the establishment for running the business, so where do the major business activities take place. Where the contract is concluded would be considered, but it is not a decisive factor. More weight would be put on the antecedent and incidental activities in relation to the performance of the contract. Place where the decision is made is crucial, and whether the business has any establishment overseas for conducting the offshore business activities for earning such offshore profit is also an important factor. Territorial source principle also applies to salaries tax. An employee shall pay salaries tax on his salary income from a Hong Kong employment. Whether it is a Hong Kong employment, consideration shall be paid firstly to where is the place of residence of the employer, then where the employment contract is negotiated and signed, and finally, where the salary is paid. If any of these three is in Hong Kong, the Inland Revenue will incline to consider it a Hong Kong employment. If the employment is not a Hong Kong employment, but the employee provides his service for the employment in Hong Kong, then such part of the income earned for services provided in Hong Kong will also be subject to Hong Kong tax, despite it is not a Hong Kong employment. However, if you stay in Hong Kong in total of not more than 60 days in a financial year, then any service provided in Hong Kong in such a year would not be taken into account for tax purpose. The financial year for Hong Kong is from the 1st of April to 31st of March of the next year. So if you stay in Hong Kong and work in Hong Kong for less than 60 days in the financial year, your salary income will not be subject to tax in Hong Kong. Even when you have a Hong Kong employment, if you can satisfy this 60 days rule, you will also be considered as providing all your services out of Hong Kong and be free from salary tax under the territorial source principle. We have property tax, which is tax on rental income from landed properties in Hong Kong. It applies only to property owners who is natural persons. If the landlord receiving the rent is a company, the landlord company will be considered as carrying on property leasing business and shall pay profit tax on such income instead of property tax. If it is a subleasing, the principal tenant further leases the property out to a subtenant, the principal tenant will be considered as carrying on a subleasing business, and then the income will again be subject to profit tax instead of property tax. Stamp duty is a tax levy on sale or transfer of landed properties in Hong Kong and shares in Hong Kong companies. It shall also be payable on tenancy or leasing agreements of landed properties. For sales or transfer of shares in Hong Kong companies, the rate of stamp duty is 0.26% of the transfer price or the net value of the shares, whichever the higher. There can be exemption if the transfer of shares are within the same group of companies or between companies under the same control. For rental or leasing agreement of landed properties, the rate of stamp duty is from 0.25% to 1% of the annual income or annual rental. Stamp duty is only payable on written documents of the relevant transaction. So if the agreement for the tenancy of the lease is a verbal one rather than in writing, no stamp duty shall be payable. However, such kind of benefit may only be enjoyed in transfer of shares or landed properties because law requires these two kinds of transaction must be done in writing. Stamp duty on transfer of landed properties in Hong Kong is at a progressive rate on the price ranging from a fixed sum of 100 Hong Kong dollar to 4.25% of transfer price or the market value, whichever the higher. Because the price of landed properties in Hong Kong has been driven very high in the recent years, the government introduced the policy that if you are not a permanent Hong Kong resident, or if you are, but you are already the owner of a residential property in Hong Kong, the progressive rate will be replaced by a fixed rate of 15% of the price or the market value. So it's a rather high one. Hong Kong has also signed a number of double taxation relief agreements with various jurisdictions, and the one with Spain was signed in 2011. So if you were in both places and have income from both places, so you may not be charged with double tax under such relief. That's my presentation, and thank you. And I will hand it over to Heidi now.
Thank you, Neville. Heidi.
Hello.
Thank you, Heidi.
Okay. Good afternoon and good morning. Buenos dias, friends and colleagues of the Madrid Bar and the Law Society of Hong Kong. I'm Heidi Choi, member of the International Legal Affairs Committee of the Law Society of Hong Kong. It's a wonderful opportunity to get connected with you online to share on part 2 on this topic, doing business in Hong Kong. In this section, I'm going to share the general laws and rules on importation into Hong Kong. What are the key restrictions and duties? Second, I would like to share the major legislations on safety regulations of consumer goods. Finally, I will briefly touch on anti-competition laws. Due to the time constraint, I will only give a brief introduction as to the key concepts and important legislations you can't ignore if you or your clients want to do business in Hong Kong. Now let's look at the first part. Importation into Hong Kong, restrictions and duties. Are there any restrictions on the importation of consumer goods and commercial goods? Generally, there are no restrictions on importing commercial goods and services. However, importing or exporting any prohibited or controlled item into or out of Hong Kong is governed by legislation. Prohibited articles are goods in respect of which the import, export, or transit thereof are prohibited or controlled under the Import and Export Ordinance, Cap 60, Laws of Hong Kong. But there are various examples of prohibited controlled items, which includes dangerous drugs, psychotropic substances, controlled chemicals, antibiotics. These are drugs. Arms, ammunition, fireworks, rough diamonds, animals, plants, endangered species, telecommunication equipment, game, meat, and poultry. So there is also a very special category of goods, namely strategic commodities. And these strategic commodities requires licenses issued by the Director General of the Trade and Industry Department to import and export out of Hong Kong. So what are these strategic commodities? Examples are industrial dual-use goods, such as electronics, computers, telecommunications, and information security goods, etc. So you may often come across situations where there are high-tech goods, which might be used in strategic products. For instance, high-tech chips for mobile phones, computers, rockets, or national defense use. So these are subject to import and export control. Applicants for import and export licenses have to make declarations of use and provide details of the end user. So this is an area you should watch out. What import duties apply to commercial goods? Hong Kong is a free port and there is no customs tariff on goods imported into Hong Kong. The Hong Kong government collects an excise duty on only 4 types of goods, irrespective of whether they are imported or manufactured locally: tobacco, hydrocarbon oil, liquor, methyl alcohol. A first registration tax is also charged on motor vehicles when first registered. Pausing here, I thought you would also be interested to learn about SIPR. The full name is Mainland and Hong Kong Closer Economic Partnership Arrangement. What is that? SIPR is a free trade agreement signed between the mainland of China and Hong Kong Special Administrative Region. SIPR enables a wide range of Hong Kong products complying with SIPR rules of origin to enjoy zero tariff treatment upon importation into the mainland, if covered by a certificate of Hong Kong origin SIPR. SIPR is nationality neutral. It means that it allows overseas entities incorporated in Hong Kong to use SIPR to enter the mainland market. So how can foreign investors benefit from SIPR? SIPR opens up big markets for Hong Kong goods and services. It also brings opportunities for foreign investors. Foreign investors are welcome to set up or just invest in businesses in Hong Kong and tap into the benefits granted by SIPR to tap into the huge mainland market. SIPR covers mainly 3 broad areas. Let me briefly introduce them to you to show how foreign investors can benefit. The first area is trade in goods. All goods that are made in Hong Kong are able to be imported into the mainland with zero tariff. The manufacturer can apply for a certificate to certify the rules of origin to ensure everything is made in Hong Kong. Foreign investors are welcome to use Hong Kong as production base so that any product they make adhere to the rules of origin and can be transported to the mainland without any tariff. The second area is trade in services. The service suppliers of Hong Kong will enjoy special treatment when entering the mainland market in several service areas. The professional bodies and regulatory authorities of the mainland have also signed several agreements and arrangements on recognizing professional qualification. This means that the best way to enter the mainland market for a foreign investor is to set up a shop in Hong Kong or to deal with a supplier who's already here. The third area is trade and investment facilitation. Both the mainland and Hong Kong have agreed to improve the cooperation between trade and investment facilitation areas to further improve general business environment. With SIPR, Hong Kong enjoys a favorable position with the mainland market by the most favored treatment provision. This provision protects Hong Kong such that if the mainland offers any kind of preferential treatment to another market, they must also offer it to the Hong Kong market, even if that preferential treatment is better than something already offered by SIPR. So for this very reason, if foreign companies look to enter the mainland China market, they should consider setting up a Hong Kong company as a springboard. My colleague Neville has already showcased the various forms of business associations in Hong Kong, so do watch out this space. Next, on part 2, I'm going to generally introduce the safety regulations of consumer goods. What are the key safety regulations of consumer goods in Hong Kong? The key legislations are the Trade Descriptions Ordinance and the Consumer Goods Safety Ordinance. Trade Descriptions Ordinance is a piece of legislation which deals with prohibition against regarding false trade descriptions and other unfair trade practices. Consumer Goods Safety Ordinance is the main piece of legislation dealing with product safety requirements. All consumer goods must comply with the general safety requirements or the safety standards and specifications prescribed by the Secretary for Commerce and Economic Development of Hong Kong. Manufacturers, importers, and suppliers, they have a duty to ensure that the consumer goods they supply are reasonably safe, including in the way the goods are presented, promoted, and marketed, the use of any mark and instructions or warnings they give for keeping, using, or consuming the goods. Manufacturers, importers, and suppliers must also adhere to the safety standards published by standards institutes or similar bodies for consumer goods when describing the goods for matters relating to such goods. Any reasonable means to make the goods safer should be considered and implemented. A due diligence defense also exists under the ordinance. And any person who sells unsafe goods commits an offense is liable to fine and imprisonment on conviction. And also, there are 2 other legislations which offer protection to consumers as contracting parties, which is the Sale of Goods Ordinance. Sale of goods contracts are mainly governed by this ordinance. Safety and suitability requirements of goods are often considered implied terms in the sale of contracts, while certain implied terms or conditions and warranties are governed by this ordinance. There is also the Control of Exemption Clauses Ordinance. This ordinance governs civil liability. It governs any terms in the contract that seek to avoid liability for breach of contract, negligence, or other types of breaches of duty. Now, pausing here, I would like to mention briefly that we expect that CISG will be implemented in Hong Kong around the 3rd quarter of this year by the Sale of Goods United Nations Convention Ordinance, CAPS 641. I'm sure that those of you in Spain, you might be quite familiar with the CISG. The CISG applies to generally commercial sales of goods, and it will not generally apply to consumer sales. The CISG applies automatically to contracts for sale of goods between parties whose places of business are in different contracting states. The CISG allows parties to opt out of the convention by agreement, so there is party autonomy. And on this very brief note, let's stay tuned for the latest developments around the 3rd quarter of this year. Now I'm coming to anti-competition law. Due to the complexity of anti-competition law and the constraints of time, I think that I'm going to be very brief to generally introduce our anti-competition regime in Hong Kong. What is competition law? There are generally 3 key competition rules under the Competition Ordinance, CAPS 619, known as the First Conduct Rule, Second Conduct Rule, and the Merger Rule. The competition rules apply to all entities engaged in economic activity, including companies, partnerships, sole traders, and trade associations, collectively referred to in the ordinance as undertakings. What is First Conduct Rule? The First Conduct Rule prohibits agreements and arrangements between undertakings that have the object or effect of preventing, restricting, or distorting competition in Hong Kong. The rule is particularly concerned with preventing cartel conduct, which is taken very seriously by the Competition Commission, which occurs when competitors agree to do one or more of the following activities: bid rigging. What is bid rigging? It is agreeing strategy when bidding for or considering whether or not to bid for projects, or when responding to invitations to tender. Market sharing, that is allocating sales, territories, customers, or markets for the production or supply of goods or services. Output limitation, which means fixing, maintaining, controlling, preventing, limiting, or eliminating the production or supply of goods or services. Price fixing, which means fixing, maintaining, increasing, or controlling the price for the supply of goods or services. What is second conduct rule? The second conduct rule prohibits undertakings that have a substantial degree of market power in a market from abusing that power. And abuse will occur when the undertaking engages in conduct that has the object or effect of preventing, restricting, or distorting competition in Hong Kong. Examples of conduct that might amount to an abuse of market power include exclusive dealing. It occurs when a supplier requires a customer to exclusively or largely acquire a good or service from the supplier, or incentivizes a customer to do so. Predatory pricing. It occurs when a business sets the price of its goods or services so low that it is deliberately foregoing profits in order to force a competitor out of the market or to discipline the competitor. Refusal to deal. It occurs when a business with substantial market power refuses to supply a product or service, or refuses to supply the goods or service on reasonable terms. Tying and bundling. Tying occurs when a supplier makes the sale of one product conditional on the purchase on a different product. Bundling occurs when two products are discounted if they are purchased together. There is also the merger rule. The merger rule prohibits mergers that have or are likely to have the effect of substantially lessening competition in Hong Kong. The rule only applies when one or more of the parties participating in the merger holds a carrier license within the meaning of the Telecommunications Ordinance. I'm coming to exemptions and exclusions. Now, the first conduct rule does not apply to agreements that enhance overall economic efficiency. So these are agreements that contribute to improving production or distribution, or promote technical or economic progress, and meet several other criteria. The first conduct rule is also excluded if the combined turnover of the parties to a relevant agreement does not exceed 200 million Hong Kong dollars. However, the exclusion does not apply to agreements involving cartel conduct. The second conduct rule does not apply to conduct by an entity that has an annual turnover not exceeding 40 million Hong Kong dollars. What are the consequences for breaching competition rules? First of all, there are pecuniary penalties. The maximum pecuniary penalty for each contravention of the competition rules is 10% of the turnover of the undertaking concerned for each year in which the contravention occurred, up to a maximum of 3 years. Even if a company in breach is a very small part of a conglomerate, the maximum fine will be by reference to the turnover of the whole group. So it is very serious. Individuals involved may also be fined. There are also others that the commission or the tribunal can order. The competition tribunal may make any order it considers appropriate against a person who has breached competition law, including disqualifying a person from acting as a director for up to 5 years, restraining and prohibiting a person from engaging in contravening conduct, and declaring an agreement to be void or voidable. A person who has suffered loss or damage as a result of any act that has been determined to be a contravention of a conduct rule may commence a follow-up action against that person who contravened the rule or who was involved in the contravention. So who enforces the law? That is the Competition Commission. The Competition Commission is responsible for investigating and enforcing the competition rules. The Communications Authority has concurrent jurisdiction in respect of anti-competitive conduct of certain undertakings in the telecommunications and broadcasting sectors. The Competition Commission has investigation powers, enforcement powers, and it is noteworthy that it also has published the enforcement policy. You will be interested to note that the Competition Commission focuses its resources on two particular types of conduct. One is cartel conduct, and the other is exclusionary behavior. Under the policy of the, there is also the leniency policy. Under the leniency policy, the commissioner will agree not to commence proceedings for pecuniary penalty and other orders against the first member of a cartel that comes forward and cooperate. Early cooperation with the commission may receive a reduced penalty. Finally, let me briefly introduce the Competition Tribunal. The tribunal is responsible for hearing and determining cases brought under the ordinance. It has jurisdiction to hear competition cases, including applications by the Commission, applications for review of Commission decisions, and private follow-up actions. If the tribunal finds that a person has contravened a competition rule, it may impose pecuniary penalties and make any other order. Thank you for the opportunity to allow me to share with the brief introduction of doing business in Hong Kong today. As you may note, there are huge opportunities for Spanish investors who are interested in doing business in Hong Kong. We do welcome exchanges with our colleagues in Madrid on how we can tap on the opportunities in doing business in Hong Kong and Spain. And I do look forward to meeting you in Hong Kong or in Spain very soon. Thank you.
Thank you very much, Heidi, and thank you to Neville as well for giving us an overview about doing business in Hong Kong. So now we'll move on to the Q&A session. I would like to invite our audience to submit any questions you may have via the Zoom chat box, and our speakers would be most happy to answer them. To start with, I myself have a question for Borja and Juan Martin, which I'm sure is of interest to many of our participants in Hong Kong. What's the stance of Spanish authorities towards Hong Kong and PRC mainland investments in Spain? And what do you see in your practice as the main challenges to Hong Kong and PRC mainland investments in Spain?
Yeah, Borja, I don't know if you want to go or.
Yes, go ahead, please.
Yeah, well, I would say that first point, the stance is generally welcoming. As I said in my presentation, there have been investments of PRC companies, mainland PRC companies and Hong Kong companies in almost all the sectors, from ports, banks, logistics, food, beverage, and energy. Very recently, Three Gorges, for example, which is an SOE, as you know, acquired a big investment in the energy sector. That's the first point. The second point, we cannot deny that the general stance towards investments generally in the world is veering into protectionism and regulations as the FDI, European regulation, are being enacted. The third point I think is fair to make is, although that regulations have resulted in a more cautious approach, mostly I think in the face of foreign investors that would not like to risk the embarrassment of their investment being rejected. I still believe that in Spain and Portugal, the general stance towards PSC investments is welcoming. In terms of challenges, I think that perception is a challenge for the flows. The second is culture. Of course, it's not the same, and you may have experienced this in your own practice. Sometimes when negotiating investments of this kind, we get lost in translation. The different negotiation styles, the different character of a Chinese or a Spanish counterpart. Sometimes for us practitioners generate a challenge to get the message through. And the third one is, of course, the regulatory roadblocks that may exist, as the ones I think I described and are similar to the one that we just heard from our Hong Kong colleagues, but in antitrust, both in antitrust and generally in FDI clearances, as well as in license permits, as I explained in my presentation, the sort of red tape that exists in Spain and that we have been trying to reduce, but it's still a problem. I mean, requires patience and a bit of good advice and guidance on the part of legal advisors.
Thanks, Juan Martin. Are there any industries which you see like a big green light, which are eager for investments? I guess, be it foreign investments or local investments, what are like the hot industries which the Spanish government or authorities are trying to promote or attract investments?
Yeah, clearly green energies, the new economy. There is a big European fund as a result of COVID that is called the Next Generation EU fund, which Spain has benefited on almost 75 billion euros, and is meant to promote investments on those sectors, on the new economy, digital economy, and also in the green environmental related sectors from energy to energy generation, renewables, and also energy savings, and those clearly are what we see as the main sectors where foreign investors are investing, and probably where mainland Chinese and Hong Kong investors are more interested as part of their own challenges in China. The agenda, the green agenda in China is very, very relevant, and as a result, I guess that a number of companies, and particularly so with companies as Free Gorges, as I explained before, that were not that much focused 10 years ago, perhaps in solar and wind energy, are now getting to those factors, not only in China but also overseas. And Spain is big market on that regard. It's one of the leading economies in terms of the volume, the part of the mix in the energy generation that is generated by renewables, and there are strong companies and of course a lot of sun. So a very fertile land for that kind of investment.
Great, thank you, Juan Martin. Borja, would you have anything else to add, or should I move on to the next question?
Well, actually, the comments from Juan Martin were perfect. I fully agree with him in the sectors, in the main challenges, the FDI and all. I wouldn't like to add anything else.
Yes, I agree. These are all very useful insights. Thank you. So turning to Heidi and Neville, can you please share with us the stance of Hong Kong authorities towards Spanish investments, and what do you see as the main challenges to Spanish investments in Hong Kong and mainland China, please? Neville, would you want to take this?
Yeah, I think all foreign investments are welcome to Hong Kong and to China, and I agree with Juan about the differences in culture. Well, actually, for mainland Chinese, their culture is quite different from the West, and in particular their style of doing business. Even for Hong Kong people first encounter them would find it difficult to do business with them, because they're always thinking about making friends first before you do any business. So one may have to adjust to that style and to understand them before you can develop the business relationship. And I think it's advisable for foreign investments or businessmen coming to Hong Kong as a stepping stone to enter China, to find a reliable local partner for entering the PLC market. I think it would be much better.
Thank you, Neville. And going back to Borja and Juan Martin, Heidi previously gave us quite a detailed overview of Hong Kong's anti-competition legal landscape. I'm wondering, what's the antitrust landscape like in Spain? Is it a hot and developing area, or is it quite developed already? What are the key things to watch out for investors?
Well,
yeah, go ahead.
Okay. Yes, the antitrust landscape in Spain is already very developed. You have to bear in mind that this is regulated or harmonized at the European Union level. So the antitrust landscape in the whole Europe, it's quite sophisticated so far. Obviously, they are strengthening and developing it in more detail, but it is quite developed right now. You have at the EU level, you have the controls, the authorities controlling all these issues about antitrust, but also at local level, at a national level, each of the jurisdictions in the EU have their bodies also. I could highlight that it is quite important, for example, for the buyers. When it comes to M&A transaction, it is quite important for the buyers when the volume of the transaction exceeds some thresholds in the market. It is quite important to get clearance, to first to assess if clearance it is required, and then if it is required, obviously to submit a formal approval by the authorities. It is quite critical. It is something which is very important to bear in mind, because well, in the worst case scenario, the transaction may be considered as null, but this is quite extreme. But obviously there could be fines, and it is something quite important to watch. And also it applies to other not only for M&A but also for anti-competitive practices. So when that would be also another recommendation when it comes to agreements, commercial agreements related, which may imply well, in a way, restriction of the prices, exclusivities, non-competition provisions, and so on. Sometimes it is forgotten, the antitrust, but it is quite important because of the fines are high, and the authorities are well, kind of checking these kind of transactions.
Great, thanks for the great tips, Borja. And finally, Borja and Juan Martin mentioned about renewable energy industries as the hot industry to watch in Spain. Can Heidi or Neville, maybe Heidi could take this. What would you think is the hot industry or hot trend right now in Hong Kong, which you would like to share with our Spanish friends here?
Thank you, Alison. I do think that it's very ESG is an extremely hot topic. Green finance is and the control of carbon emission. We do have a target to meet. So we do expect that there are a lot of investment or fundraising activities relating to green energy and renewable energy. So to encourage the ESG, the corporate governance, and also social corporate responsibilities, that we have to maintain the sustainability business structure and culture, so that we have to aim for the future for the humankind. So we will see that there are a lot of government initiatives, including the Hong Kong Monetary Authority, taking the lead to encourage businesses and also listed companies that they have to look at their ESG policies in their annual submissions to ensure that they are in line, they have incorporated ESG elements into their corporate strategies. So these are the areas that I think that we can't miss out. And also on the fintech area, and I think that that is something that is also booming in Hong Kong. And also there are also financial services that we have to watch out. I'm sure that Neville can supplement on the Wealth Connect. The Wealth Connect is actually connecting investments into and out of Hong Kong, between the mainland and Hong Kong. So individual investors, they can directly invest into stocks and shares in the Hong Kong companies and listed in Hong Kong. So they that will facilitate trade, and they will also facilitate capital movement and also the booming of the financial market. Neville, do you have anything to add?
So you're right. I think what we're usually talking about now as a hot topic is the so-called family office by the mainland entrepreneurs, because they get rich and get lots of wealth and assets. They want to know how to protect them, as it would pass down to generations, and inflation is so terrible. Then they would always thinking about how they can put their money anywhere in the world and to safeguard the value. So it's a very hot topic, and but many lawyers and accountants are thinking about the way to serve their clients. It's a very, very hot topic. So I think it would be some cross-border matters than lawyers from different jurisdictions may work together to serve our clients on this area.
Great. Thank you, Heidi and Neville. Thank you to all our speakers for your great presentations and all the sharing. Personally, I think it is really encouraging to hear that renewable energy and ESG are under the spotlight, both in Hong Kong and Spain. And we do hope that our presentation and discussions have helped our audience to better understand and grasp the exciting opportunities in both markets. Now we would like to move on to the closing remarks, which will be delivered by Maria, board member of the Madrid Bar Association, and Amarali, Vice President of the Law Society of Hong Kong and Chairman of the International Legal Affairs Committee. May I please first hand to Maria? Thank you.
Thank you very much, Alison.
Thank you.
I would like to begin these closing remarks by thanking the President of the Law Society of Hong Kong and the President of the Madrid Bar Association for opening this webinar and for sharing their initial thoughts. It has been a privilege to hear from both. I would also like to congratulate our distinguished speakers for their excellent performance and for their fruitful exchange of ideas and knowledge. I can firmly say that we have all learned from their insights. Finally, I would like to thank all the participants in this webinar that have joined us throughout the almost 2 hours that we've been sharing our thoughts. I have been told that at some point there were more than 130 people from Spain and Hong Kong connected. Thank you very much to all of you for making this webinar possible. As Deputy of the Madrid Bar Association's government body in charge of the international relationships, it has been an honor for me and for this institution to participate and co-organize this joint webinar, doing business in Hong Kong and Spain. I'm confident that we have all gained useful knowledge and have a better understanding now of how of the latest developments in setting up and doing business in Hong Kong and Spain works. There's no doubt that every day transborder activity, commercial exchange, investments and partnerships between our our two jurisdictions are becoming stronger and more diverse than ever. The visits of the Hong Kong Trade Development to Madrid and the Spanish Institute for Foreign Exchange, the ISEX, to Hong Kong in the last couple of years reflect that Hong Kong and Spain have increasingly become important economic partners, as the Madrid Bar President earlier mentioned. There is no doubt that understanding the legal ecosystem is essential for companies when they enter markets which have not been explored in the past or have been poorly explored. As we surely all agree, events like this one, which help to connect legal and business professionals, are even more important now. With a world that is recovering from a global pandemic, which has dramatically disrupted the health, financial welfare, social order, and political stability of all nations, and ours are not an exception. I strongly believe that bar associations have the duty to accompany legal practitioners with this continuing sharing of legal knowledge, so that we can also share this with our clients. By stimulating the connection within practitioners of our jurisdictions, we will be able to keep facilitating business and clients to extend these economic relations, which will benefit our both nations. For these reasons, the Madrid Bar Association will always support forums, webinars, and roundtables of close allies, such as the Law Society of Hong Kong proves to be. The Madrid Bar Association has always taken interest in participating in the Law Society's President's Roundtables. Today, we reaffirm our interest in joining and co-organizing future events. The Madrid Bar Association and the Law Society of Hong Kong relationship can go and will go on beyond this. Thank you very much and congratulations to all.
Thank you, Maria. We have Amarali now, please?
Thank you very much.
Thank you.
Buenos dias, everyone. I'm pleased to see that the seminar has been conducted very efficiently, and I'd like to thank Mr. C.M. Chan, President of the Law Society of Hong Kong, Mr. Jose Maria Alonso Puig, Dean of the Madrid Bar Association, also Borja and Juan, who've spoken and given us details of Spain, as well as Neville Chang, Heidi and Alison for participating. Finally, Maria, Sigmund, and of course the translators. I was actually in Spain in 2019, 3 times, and I visited the Madrid Bar Association, and at that time discussed possibilities of webinars and other connections with Latin America, and very glad to hear that this has now come to fruition. One thing I found when I was in Spain was that Chinese companies and Spanish companies, when negotiating contracts, some of them actually chose Hong Kong as the law of Hong Kong as part of the contract for arbitrations, and that was very interesting. One other thing I found, I know you've mentioned cultural differences, but there is one cultural similarity which divides, which actually consolidates those differences, and that's food. The love of food of Spanish people and the love of food of Hong Kong is, I think, the binding force of culture. And with that, I'd like to bid you all a good evening and a good lunch or a good dinner. Thank you very much.
Thank you, Amarali. Thank you all once again for joining us today. We hope that you all have some good takeaways from our webinar, and we look forward to seeing and building more collaboration and partnerships between Spain and Hong Kong going forward. Adios, goodbye.